Hello and welcome to episode 10 of my Employment Law Snapshots. In this episode I'll be talking about the weather, religious discrimination and Pokemon. It's good to see that the summer has eventually decided to turn up, and I hope that you've been enjoying this week's sunny weather. Obviously, as a fully paid up member of the ginger community, I've spent most of this week running from one area of shade to another. To be honest, I have been known to get sunburn even when I lie too close to the bedside lamp. Anyway, this week's snapshot deals with the important issue of religious discrimination in the workplace. I'll be looking at two contrasting Advocate General opinions on whether it's discriminatory for employers to ban wearing headscarves in the workplace. On with the law. This week's cases are called Achbita against G4S and Bugnawi against Micropole. The facts in both of these cases are relatively straightforward. In Achbita, Miss Achbita worked for G4S as a receptionist in Belgium. G4S employees in Belgium aren't allowed to wear any religious, political or philosophical symbols while on duty. 3 years into her employment, she began to wear a headscarf at work, and she was ultimately dismissed for refusing to abide by the dress code. In the Bugnawi case, which occurred in France, Miss Bugnawi was a design engineer for Micropole, and she was told when she was recruited that due to the customer-facing nature of her role, she'd not be able to wear her headscarf at work. A customer soon complained about her headscarf, and when she refused to remove it, she was also ultimately dismissed. Both the Belgian and French courts referred the cases on a preliminary question to the European Court of Justice. In simple terms, the ECJ was asked whether a ban on employees wearing a headscarf at work constituted direct religious discrimination. In Achbita, Advocate General Cocotte gave the opinion that G4S's ban on wearing religious symbols was not direct religious discrimination. This was on the basis that the ban affected all employees equally, and it wasn't based on stereotypes or prejudice against a particular religion. The Advocate General went on to say that even if it was religious discrimination, the headscarf ban could be a genuine occupational requirement on the basis of G4S's objective of religious neutrality, and this was a legitimate commercial choice given the broad range of clients that it had. However, in the Bugnawi case, and in direct contrast to the Achbita case, Advocate General Sharpton's opinion was that the dismissal of Miss Bugnawi was direct religious discrimination. The Advocate General's opinion was that it was clear that Miss Bugnawi had been treated less favourably on the ground of her religion than a comparator would have been treated, i.e. an employee who hadn't chosen to manifest their religious belief by wearing particular clothes would not have been dismissed. In contrast to Advocate General Cocotte's view, in the Achbita case, Advocate General Sharpton said the argument that a headscarf ban was a genuine occupational requirement was not available in this case because it couldn't be used to justify a blanket ban on wearing religious clothing. The only situations where the Advocate General considered that a ban might be justifiable was perhaps where there were serious health and safety concerns, such as banning the wearing of a turban where a job required particular protective headgear. Interestingly, in the Bugnawi case, the employer also tried to argue that the ban was justified for commercial reasons arising out of the customer complaint. However, this was given short shrift by the Advocate General when she said that religious discrimination cannot be justified on the ground of commercial interest. Now it's going to be up to the ECJ to try to resolve the difference of opinion between the two Advocate Generals when it reaches its final decision on these two cases in the coming months. As it stands at the moment, it's probably fair to say that an outright ban on wearing religious clothing as symbols at work is a risky policy to adopt. You'll no doubt remember the case of Oweda, where the European Court of Human Rights said that the UK had failed to protect Miss Oweda's rights to wear a discreet cross outside her British Airways uniform. We should hopefully have a definitive answer by the end of the year on these two cases, so watch this space. And finally, on a lighter note, I'm sure by now that you'll all have heard about the new Pokemon Go craze. Frankly, I haven't got a clue what it is. I'm more of a Space Invaders and Pac-Man person. Apparently the game involves people wandering around aimlessly while staring at their mobile phones. Well, the current Mrs. Tibble says that I don't need a game to be able to do that. Whilst this all sounds fascinating, some employers, including the likes of Boeing, have already banned it during work time to prevent employees from walking into things, presumably propellers. On the flip side, one man in New Zealand has actually given up his job as a barista to hunt down these little Pokemons on a full-time basis. What a world. Until next time. Thanks for watching. I hope you enjoyed this episode. If you want to subscribe to our YouTube channel for more updates, click here. If you want to follow us on our Twitter page, which gives you a daily heads up about everything employment law related, click here. Or if you just want any more information or help, please go to our website by clicking here. And all of the links are also below. Once again, thanks for watching and see you next time.